My lord.
This is the difficulty of keeping the appeal pending for so many years.
My lord,
I'm not taking any steps.
no, my lord, we are, my lord, paper book, my lord, I shall file today. It is ready, my lord. The
2011
copies,
appeal, you are filing paper book today.
my lord, the
2011
my lord,
appeal, you are filing it in 2025.
yes, my lord, but my lord, the lower court record, I am sorry, the trial court records was not available, so my lord, we could not prepare. Now, my lord, we are prepared. Today, we are going to file the paper book in the department. And now,
But the notice of appeal is incomplete, sir.
my lord, notice of appeal, my lord, so far as the other respondents, the learned advocates, my lord, entered appearance, but it appears that she has not filed the Wakalat Nama. If she has not filed the Wakalat Nama, then I have to again take steps for, my lord, sending notice upon them by registered post.
So the advocates who have not entered appearance as yet, so personal service has to be effected upon those respondents.
Yes, my lord, again, my lord, my lord, notice of appeal has to be sent, my lord, upon them by registered post.
For sure.
Your Lordships, I'm appearing for the appellants. On the previous date, your Lordships were pleased to ask for a report from the office regarding mismatch of signatures in the Wakalat Nama on behalf of the respondents, number 16A to 16C. Today was fixed for the submission of the office report.
Now, what is the application for? Any application pending?
But on the earlier occasion, my lord, there was a direction to issue administrative notice, my lord.
They have been served.
Yes, my lord.
So the appeal has to be heard.
Appeal has to be heard, my lord. Kindly fixes a day after vacation, my lord. Mr. Kormokar is appearing in this matter.
For the defendants,
No, around the appeal.
We are for the appellants.
in the defendant in the suit.
Yes, my lord.
Suit for?
But suit for partition, my lord. But preliminary issue, my lord. Decided, my lord. But it's a work of property, my lord. But kindly comes to the judgment, my lord, page 54.
In spite of service or administrative office.
I am for the appellant. This is for compliance, my lord. We have deposited the my lord, written up notice form and the special messenger cost on my lord 2nd September.
Service upon the respondent number.
You are representing?
Respondent.
No, not
For the
all, not all
respondents.
of them, my lord. Service was to be made upon respondent number 2 and 6 to 9. We have my lord put in the
No,
requisition.
6, 7, 8, 9, 11, all of you are representatives. You have filed your Wakalat Nama.
Yes, yes, yes. Long before. And LCR, your lordship is directed
for
to
we have
call
deposited.
for the LCR, and on this core matter, the special messenger
So why it
post
is
has
appearing today?
put into
Your lordship directed not for compliance because
compliance.
directions were passed. Your lordship kept the matter for compliance of these
Compliance.
directions. LCR was called for and rest of the respondents to be served.
And paperwork has also already submitted before your lordship.
এসে গেছে TCR এসছে? In view of non-compliance of the order dated
corrected. Date of the order may be corrected. It is 16/8/2025. It will be 16/9/2025.
or
Lordship, I'm for the independent in this matter. Item number
you are for
5.
the
Item number 5. I'm the dependent.
5 is over, yes. Yes. Error in the
My lord, I am for the appellate.
My lord, I am for the respondent. My lord, I have mentioned it for correction. My lord, if your lordship kindly see, my lord, 6, note 6, my lord, page 2. My lord, trial court records was directed to be brought by the cost of the appellant. My lord, initially your lordships, my lord, dictated that it will be by the cost of the respondent. But my lord, since my learned friend has already deposited the cost, so my lord, this can be ignored. And so far as the 7 is concerned, my lord,
you are the respondent.
I am the respondent.
Appellant.
So you have deposited the cost.
Yes, I have deposited.
So why you are mentioning this?
My lord, initially when this order was passed, your lordship directed us to, my lord, put in the special.
Let the record be called 2 weeks from date at the cost of the appellant is already there.
She has already deposited the cost. And my lord, so far as the other part is concerned, preparation of paper book and service of notice of the trial arrival of trial court record. If my learned friend is willing to prepare paper book, my lord, within the
The appellant shall prepare the
We
paper
will
already.
prepare. We have
Direction is there
deposited
already.
the cost by Monday.
No, direction is already there. Yes, yes. Next.
Fine.
Yes, next.
So I'm for the appellant, also the plaintiff. Now, also in terms of your lordship direction dated 25th August 2025, I have deposited the special messenger cost on
But why it has come?
lordship for compliance that your lordship directed to paid.
You are appearing for
Respondent number 1.
anyone for 2, 3, and 4? Anyone for 2, 3, and 4? Undelivered. Correct. So you take steps for change of the name. Take down.
Number 9, my lord, I declare for the appellant. It is present before your lordship for correction, my lord.
Correction.
We are seeking for one small indulgence, my lord. In the part where my lord recorded our submission, my lord, in paragraph number 9 has recorded that, however, as on date, the sanction plan has not been renewed. My lord, we seek it to be corrected to development agreement because it is a development
Complete the
agreement that is not.
construction. However, as on date, the sanction plan has not yet been renewed.
My lord, we are seeking the sanction plan be changed to development agreement because we have no instruction regarding the sanction plan. Whereas the development agreement.
No correction, no correction. No correction. Yes, next.
Number 10. In this matter, I am for the appellant. Your lordship kindly come to paragraph 4 of the order. I believe, my lord, this should be this bench. Instead of a coordinate bench, it should be this bench. And the order should be 20th of August, 20 August.
No, we dispose of the appeal. Nothing remains in the appeal.
Absolutely, my lord is correct because my lord only my lord I have also gone through. I'm fairly submitting, but my lord, my only prayer, my lord, kindly do not
May it please the Lordship.
Yes.
I'm appearing on behalf of the respondent numbers 1, 2, and 3.
This will require, my lord, some time, my lord. But this is in connection with, my lord, Benami property transaction. My lord, there's one property where, my lord, the appellant before your lordship, my lord, and the original writ petitioners, my lord, were owners, my lord. Lordship will kindly take, my lord.
Now, please tell me, you are for the department.
Yes, my lord.
Now, please tell me that confiscation order,
My lord.
was it passed in his presence?
No.
No.
Then what we can do is this, subject to hearing you, whatever 1.90 crores he has received, he will not deal with that money till the confiscation proceeding is concluded. And after giving an opportunity of hearing, you conclude the proceeding till such time, in effect, it will stands attached. But they may not have to deposit the amount.
May I submit one thing, my lord?
Okay,
My lord, the appellant is not entitled to any notice in this matter, my lord. Kindly see the order.
They are not entitled to any notice.
My lord, kindly see these orders.
They are not entitled to any notice.
No, they are not entitled to notice
but-
because neither.
See,
my-
it's like a garnishee proceeding you are doing, correct? You are doing a garnishee proceeding. So the garnishee will have a right to say whether he is entitled. So his case has to be considered.
Absolutely.
You are considering that he becomes now a debtor by receipt of such amount. So you are recoverable. So according to you, his money is being held by him in Benami.
Correct.
No.
That is the
That is not. That is the case. He is not holding as Benamdar.
It is a part of an advance payment, according to them. He has received back the amount of 1.90 crores, correct? You have issued a confiscation order attaching this money, which according to you is the money of that person who has transferred.
Who is the Benamdar?
Correct.
Benamdar who has transferred this
Benamdar
money.
who has transferred the amount to you. If he has any independent right to show that out
He
of
has
it,
no right at all, my lord. That's why I'm showing, my lord, from this order, my lord.
now this order is there, his order is here.
Yes, my lord. Can you see the my lord?
This
Here,
is
my
the impugned
lord,
order.
here, my lord, in this, the appellant is claiming that that amount was given in pursuance of an agreement for sale. That agreement of sale stood
You are saying
cancelled.
it's a fraudulent transfer.
The agreement for, as per their own admission, that agreement for sale stood cancelled.
Should cancel.
Where have I admitted, my lord? Two things, my lord.
Position.
Two things, my lord. The department, my lord, comes up every day and hands over one single piecemeal document. We are in custody of all the documents, my lord.
Have you cancelled the agreement?
No, my lord.
Yes, my lord.
We have not. We have not.
But-
There was, my lord, may I
On earlier
let them
occasion, those documents were
Sharma.
submitted.
एक मिनट रुक.
No, court is asking. That's why I'm.
No, it's cancelled.
Yes, my lord. Can you see this?
It is
I had,
cancelled, then cancelled.
My instructions
says
are, my lord,
that
it is not been cancelled, my lord. This is an communication, my lord, from my erstwhile.
SN Dhawan and Company LLP to the initiating officer.
Yes.
We are representing such and such the company.
This has not been given effect to, my lord. I have documents to show, my lord. Let them come up with all the documents and let them come up by way of an affidavit, my lord. Throwing up a document before the court, my lord, perhaps, my lord, would not suffice.
Just a minute. You are starting in
Yes, I am static.
And this communication was submitted to the initiating officer during 24/1 proceedings.
The company has a legal right over this property by virtue of the allotment made to the company. No further payment was made as the company did not complete the construction of tower as it is in progress. You are static.
I'm sorry, my lord.
Yes.
I am static.
No, you have an agreement
With
took
Sunima.
a decision to sell your rights
Yes.
over the residential apartment to
Yes.
Sumitra, who is a Benami.
Yes. Yes.
Now,
Sunima.
So your claim is against whom?
Against Sunima. Sunima.
Against Sunima.
Sunima.
A
Who
copy
has
of the
alleged,
statement
who has
is sent.
transferred the money to us, my lord. Now they are coming after
Have you
my
seen
money.
that the said transactions are genuine? A copy of the crore was received from Sunima in December.
My lord, my short point is twofold, my lord. First is, my lord,
But this agreement was not cancelled.
no, cancel.
This they say that under the agreement, StarTech wanted to sell, StarTech sold the property, Sunima has paid the consideration.
Can we see the paragraph 7-8, my lord?
It may be noted that the agreement with Sunima stands cancelled in June
Yes,
2020.
cancel.
In June 2020,
Yes.
via correspondence.
Now the
This
kindly
is
see the
one
letter
of a
Sunima,
series of documents, my lord, which the department is showing, my lord. If the department is so sure, my lord,
Your chartered accountant has written a letter.
now, my lord, may I say this, my lord?
Prima facie stands cancelled.
No, it is not. We have documents to show. After that, there are certain other documents that it has not been cancelled, my lord. But
Initiation, no. That cannot be an improvement subsequent there.
yes, my lord. Why I say this?
It's an order of 23rd February 2021. That is.
It is not an order. It's a communication, my lord.
No, order in the sense I'm saying that this relates to an order on 21st December 2020. So order was passed on 21st December 2020. In 2021, you made a representation. You have said these are all 2014 transactions, and then this agreement with them was cancelled in June 2020. So if it's cancelled, if they have paid you any amount, whatever is there under the agreement, till such date, you may have a right to forfeit to that extent. But the entire consideration, if it has passed, then they became the owner.
May I say this, my lord?
So what you do is this.
there is another aspect, my lord. The proceedings under Benami Act was initiated by attachment order. Attachment proceedings under section 24.
See,
During that proceedings, my lord, notice was given.
No, so what we do is this. This amount of money we are not allowing them to part with.
Yes, that is fine.
So confiscation
My
order,
right, my lord, should be
revisit them.
adjudicated before the authority, my lord.
You revisit it
Yes.
by giving them an if they have any right, because they are ultimately agreed by this. Whether they will be ultimately able to resist in terms of paragraph 7.
Grateful.
That
Grateful.
you have to take a decision.
I'm only on this, my lord.
So simply we'll dispose of the writ itself.
Yes,
We'll
my lord.
direct you to give an opportunity of hearing to produce all the documents
Grateful, my lord.
and take a
Let,
decision.
my lord, the adjudicating authority, my lord, under section
There are
27, my
several
lord,
aspects.
dismiss my application, my lord.
First of all, my lord, before filing this appeal, the appellant has filed an application before the writ court.
Before the
writ court, London single bench, for modification of the order.
We have not pressed that. We have not pressed that because subsequently
Thereafter,
this appeal
I
has
filed
been
this
filed.
appeal. Second,
But I have advised not to press that.
this adjudication order under section 26,
see
that has not been challenged by anyone.
no. Who can challenge it? The person who is affected by this order is challenged.
I am affected.
Now, what he is saying is this: this Suminak, or what is it, Sumia? He was an agreement holder. He was an agreement holder, and this infrastructure development was they may be developing the property. They are the builder. They want to sell the property, so they sell the property to this Sunima.
No, not so. Not so.
Yes.
No. That was the StarTech was entered into an agreement with Sunima to sell their right in respect of an apartment.
So
StarTech was the owner of the property, my lord. Somebody else was developing. I wanted to
StarTech
purchase a
took the
property
decision
and
to
then I
sell
transfer my
to
rights.
sell the rights of StarTech development
To Sunima.
So StarTech remained as the owner.
Yes. Yes.
Now, if I cancel it, then I remain as a owner.
Mother, here the property is not the apartment. Property is not asset, is not apartment. Asset is money.
There has to be some source. The money cannot come. Money is the liquid form of the asset.
Here, asset is, no, I'm just clarifying.
No. If I sell the property to you, so I decide to sell it my right to you. You may have advanced some money to me. Then I cancel it.
My lord.
So under the agreement, whatever amount I have received, I have a right to forfeit. Or you may have a right to claim that you have wrongfully forfeited the amount. So I became the owner of the fund. So by cancellation, it does not take your case forward. It may be your money, you have given it to me. If you have given your money to me, it was under an agreement. Now, what you need to find out, that is why I said that whether it is a fraudulent transaction. So this is a make-believe story. You have a right to leave the veil to find out.
My lord, that was already found out, my lord.
They were not heard.
No, yes, that
Where?
was saying, sir.
Where?
Under during proceedings under section 24.
They were heard.
Sir,
Yes,
that is a
this
previous proceeding.
communication was submitted by the appellant to the initiating officer. How will I get that document?
May I?
This document does not support the case because
Yes.
this document says I have cancelled it.
I have cancelled. Sunima is also said that cancelled. Agreement was cancelled. Yes.
Correct.
Sir.
So any money I have received under the agreement, it can be I may under the agreement may adjust it against I can forfeit the amount.
Correct.
But unless you show that it's a fraudulent transaction. So it's a fraudulent transaction to avoid the liability. Suppose is it a customs or what is the act? What is
This is a Benami Act, Millet.
Benami.
This is
Benami
Prohibition of Benami Property Transactions Act.
So it will have a impact on the revenue.
Yes.
So suppose this Sunima or they whatever the case may be, they have a liability to discharge towards revenue. So the law is well settled. You can always leave the veil and find out. So all that we are saying, we are not going to the merits of the matter. All I say that you decide this
Under
confiscation
section
order.
26 and section 27 of the Act, the provision is there, Millet. The power of lifting of
So
the veil
we
is
are only
there
saying
itself.
because you see the keeping the writ petition would be of no use.
Precisely.
So you decide maybe 4 weeks, 6 weeks, whatever is there. Till such time, the amount shall stand attached. All
Amount is already attached, my lord.
yes,
The
the
amount,
attachment order will.
that's why after confiscation, my lord, this amount becomes property of the government.
Exactly.
Yeah, this
So what
property
is
is
saying that
now the department is only proceeding to recover that.
so the money
Notice has been given to them.
the attachment we are not
No
disturbing.
notice. Only a
So whatever
subsequent.
you take steps after the attachment, you adjust it, recover.
My lord, the confiscation notice has been given to the appellant.
Millet, may I, Mr. Sharma has taken considerable amount of time, Millet. May I please, Millet? There's a tendency to mislead the court
No, my lord.
in many manners, Millet. Please.
Exception to this kind of.
Lordship will kindly see the scheme of the Act itself. Lordship will kindly take section 26 once on a receipt of a reference under subsection 5 of section 24. The adjudicating authority shall issue notice to furnish such documents, particulars or evidence as is considered necessary on the date to be specified therein on the following persons, namely, A, the person specified as Benamdar, Sunima got the notice, I have no problem. B, any person referred to as the beneficial owner, somebody else, I am not concerned. C, any interested party, including a banking company. I'm not a banking company. I am in D, any person who has made a claim in respect of the property.
Money is with you, it stands attached.
No, money is not with me. Money is with me.
No, it's attached.
It's attached.
Means they cannot use the money.
We are not.
Now the physical form of realizing.
Yes.
We are only deferring it till maybe 4 weeks, 6 weeks. You take a call. Till such time this order will stand attached. Realization is deferred by 6 weeks till the
Let us
final.
given an opportunity, my lord, in terms of
only tomorrow, my lord. I'm not taking much time. Only for tomorrow that I will contact
all that you take instruction. See, irrespective of the instruction, what we are saying is this: that this power is with you. This money is not going back to them. The money remains attached. So all that we say that you adjudicate on this by giving them an opportunity and dispose of the thing. Still such time it will stand attached. We dispose of it.
Malad, may I come back tomorrow, Malad? Just
very well.
Only for tomorrow.
Fair enough. Grateful, my lord. Grateful, my lord. I appear along with Mr. Chatterjee.
Yes, call the list.
Serial number 14.
Section one.
But in this matter, I am from the appellate. Third party,
Yes.
my lord's direction, I have
Yes, yes. Confiscation.
pursuant to my lord's direction, I sent the copies of the addition of party to the respondents, my lord. I have also affirmed the affidavit of service to the effect that the opposite parties number 1 to 4 have been served.
What is the report of service?
The affidavit of service has been prepared on the last week, but my lord, it is not tagged with this file.
But where is he? Where is he?
Your lordship,
Fresh
kindly take it
service
as
be
tomorrow, I
effective.
can produce the affidavit of service.
No, no. Have you complied with paragraph 5 of our order?
Yes, my lord, I have sent the copies of the application for additional party to the opposite parties number 1 to 4. Appellate respondents number 1 to 4.
Now, where is affidavit of service?
Well, affidavit of service, the office copy is with me, but when the original office copies has not been kept with this file, therefore I could not. Man, kindly take it tomorrow, man. It has been affirmed last week. Man, on file.
Wednesday. Next. Next.
Well, I'm good.
Serial number 15.
My lord, Mr. Parthopratimra is appearing for the appellant, my lord. He is engaged in courtroom number 6, my lord. I'm praying for a very short passover, my
He
lord.
cannot appear alone. He has a junior. What does this matter?
My lord, he will be there in 10 minutes, my lord.
There's an advocate on record. Where is he? Where is Mr. Somrat Chakraborty?
My lord, I am the advocate on record, my lord.
You are Somrat Chakraborty.
My lord, I am.
So what is the matter? Have you filed the certified copy?
My lord, I beg your pardon, my lord. I'm not aware of the facts, my lord.
You are supposed to remove this.
I understand, my lord. My lord, I'll take instruction regarding that, my lord.
Revised report question.
My lord,
Yes, certified
the
copy of.
certified copy, my lord, yes, my lord. The certified copies have been submitted, my lord. The last occasion, my lord, directed to submit, my lord.
We'll make it not today. Next.
My lord.
Next. Yes.
Serial number 16.
My lord, the appeal is preferred against the refusal to pass an ad interim order. Now, my lord, the matter is fixed tomorrow before the commercial
You
court.
have tomorrow.
I'll just take
raising
it
a
up to 1
question
minute.
with regard to my lord maintainability. It's a commercial appeal, my lord. It's only, my lord, been directed that, my lord, my order 7, rule 11 will be heard.
My lord,
Thereafter, my lord, yes.
may I make my submission? My
What
appeal?
is the matter fixed?
My lord, I'll just tell you what you bought. My lord, please see, my lord, the order by which the my lord suit
Mr.
was
Shah, the
admitted.
matter is fixed tomorrow.
My lord, I'll my lord, take 1 minute of your lordship's time. My lord, because of urgency, my lord, rule 12A was dispensed with. Requirements of 12A was dispensed with. That happened on
12 dispensed with automatically does not mean that
no.
you have a right
My lord, my learned friend has, my lord, filed an application on Order 7 Rule 11. I am only praying that, my lord, here the learned judge has fixed only the application on Order 7 Rule 11 tomorrow. I am saying let my application for injunction be taken up along with it. That is all. Let both of
My
them
lord,
be
I
heard
can show, my
together.
lord, here and now that, my lord, why, my lord, the suit should be dismissed.
If the event is decided against them, then the application for injunction will be taken up
Yes, absolutely.
immediately thereafter.
Grateful.
It will be taken up immediately thereafter.
Of that application and then, my lord, take up.
Yes, because once it is entertained, he may have some reason.
No, because my lord, ultimately, my lord, if the matters are heard together, if the learned judge is of the opinion that suit is not maintainable, naturally everything will go. But my lord, otherwise, my lord, there will be another date, my lord, fixed for hearing of the Order 39 Rule 1.
So we said that if it is held against them, then he should immediately take up the application for injunction.
Well, I'll tell you,
My
Lord,
lord, it's
the
fixed
difficulty that-
10:30 tomorrow sharp, my lord. That's what, my lord, it says. Order 7-11.
Yes.
well, that's for
Maintain
Order
the
7, that's
No,
for the
no,
Order
several-
7 Rule 11 hearing, not for the injunction. That
No,
is
he said that by this order, she will take up.
Yes.
That's what I'm saying.
Grateful.
That in the event, she will take up this matter tomorrow. When you file you put up petition with this order. So if you decide against them, then the injunction will be taken up.
Well, Lord, may I make only one, my lord, very humble prayer? I think it will appeal to both my learned. Well, Lord, the difficulty that is arising at present, my lord, certain properties have been sold to me. The allegation is, my lord, the sale is collusive and has been made an unvalue. We, my lord, deny that.
First of all, the court has to see that the court has jurisdiction or not. If there is serious dispute about that, the court may not incline to pass an interim order.
No, well, I quite appreciate
I can
that.
show on the face
I
of
can
it.
quite
That's why, my lord, I didn't
appreciate
go into it. My lord, I also did not press, my lord, because I
No, my lord,
cannot
the
show that the
vehemence
appeal
with
is
which
not
my learned
maintainable.
friend arguments can be met with equal vehemence because, my lord, I have registered sale deeds in my favor, which still set aside,
All
my lord, ultimately
collusive
vests in me
deeds
the
are
right to the
registered.
property and the right to receive all
Not
rents and fees.
commercial, non-commercial. So where you can get an interim order if you have that fact. So you prepare also a plaint for the non-commercial purpose. So once it is dismissed, you file.
No, my lord, commercial, my lord, if my learned friend says it's
But
not a
I'm saying-
commercial
I'm
suit,
saying
then that's another thing. Because my learned friends,
But your friend saying there is
my
commercial.
learned friends have also
would
filed a
not
suit for cancellation within the commercial division.
Because by concession, you cannot decide.
No, I don't think, my lord, that will be the issue. The issue has to be
Concession,
something else.
either you confer or not to confer the jurisdiction, it doesn't arise.
Well, only, my lord, I do appreciate that, my lord, your lordship, my lord, wants that issue to be decided first. But, my lord, the only question is, my lord, since, my lord, the law is settled on the subject, that, my lord, your lordship may proceed to, my lord, entertain interim prayers or interlocutory prayers, my lord, pending the
No,
decision.
since first this matter is fixed, let her hear out the matter. See, for rejection of a plaint, it does not take much time. The plaint has to be seen only. And if she decides that something is in your favor, and then may consider.
Well, I was suggesting, my lord, a via media which may appeal to my learned friend also, my lord. That is, my lord, that's why I just want one benefit of your lordship's time. My lord, the sale deeds have been executed in my favor. I am now, my lord, collecting lease rent from, my lord, the lessees. Well, there were lessees in the property which has been sold to me. I wanted to collect lease rents from those properties. Now, my lord, just 1 minute, Mr. Vanish. Now, my learned friends are, my lord, raising rent bills on those lessees. My lord, that is, my lord, the point of, my lord, controversy at this moment, who collects the rent. I was suggesting, my lord, till the disposal of this application, well, your lordship may direct, my lord, the rent to be, my lord, kept with a special officer.
You may make the same prayer to the trial court.
He was a tenant. He
No, no.
purchased, my lord, my
Well, where is
managing
the
director 2
difficulty?
days before he retired. He had no power to sell. There's no power of attorney given to him, my lord, to sell the property. He sold it to him
My
2
lord,
days before his
Is
retirement.
my learned friend arguing the suit now?
And, my lord, when I write to him, I can show that letter. First reaction is, please take back the property.
Well, I can show your lordship.
Doctrine of indoor management would come.
No, he said, take back the property.
No.
He said, I'm
No, my
sorry,
lord.
take back the property.
No, I
That's
said,
his letter.
I am
Kindly,
still
my lord,
saying,
look at-
well, I am still saying, take
my lord,
back the
page
property,
800,
pay me back the
this
money
is-
that I have paid, pay me back the stamp duty that I
And
have
now
paid,
you want to say you
pay
want
me
to
back
collect
the
it?
registration. Well, let my learned friend
Annexure
agree to
L
that,
at page
and still,
800.
my lord, I'll
No,
take
but he
instruction.
said that you wanted to return the money.
Page 800.
He says,
Well,
you
After, my lord, all this, of course, my lord, we'll return the money. We want the property back.
Well,
That
if
will
my
be
learned
decided
friend-
there. Of course, we want it.
agreement.
We have asked for, my lord, we have also filed a suit asking, my lord, for declaration, my lord.
Well,
that we need it.
I have, my lord, not made a concession. My lord,
But
I just
I-
didn't want unnecessary trouble because I own, my lord, almost 80% of the mall I own. I have purchased it over the years.
2008, from 2008.
My lord, so my learned friend is talking about, my lord, only the balance 20%, which is now in issue. And well, I can show your lordship that, my lord, the transaction values over the years
The
have
matter
been
be
much
decided
less than
tomorrow,
that.
my lord. They fixed it, my lord, tomorrow.
I am
for finishing on the
saying
same day.
that, my lord, in the meantime,
On
my
the
lord, let
23rd.
my lord no rent be
In the
paid.
meantime means tomorrow is 10:30. So in the meantime,
Take a chair.
That's right.
and we said immediately thereafter if it's different.
Grateful.
Serial number 17.
17, Your Lordship, I appear on behalf of the petitioner. Your Lordship had directed us to serve a copy on the other side because there was a copy of the condonation application for condonation of delay. Some have come back as left, some has come back as refused. Lordship, I am carrying a Lordship.
You take appropriate steps.
Lordship, I was just humbly praying to remand this back because, Your Lordship, the ad interim injunction was refused only on the ground that I've produced photocopy of the documents. So I'm not praying any adverse order as of now. I'm just requesting Your Lordship to remand it back to hear afresh with and an opportunity for me to produce the original. If Your Lordship peruses the impugned order, second paragraph, last line. What the plaintiff at this stage produces photocopy of a letter of.
We have not produced the original or photocopy.
Lordship, subject to correction.
The order is perfect.
Lordship, kindly appreciates. Lordship, I have produced a photocopy, but not the original.
No, you have to neither produce the original or photocopy
Of any document of agreement between him and the father of the, nor any document of contract between him and the father of the defendant in respect of sale. What plaintiff at this produces is a photocopy of the letter of offer. Lordship, which kindly uses that, Your Lordship. That's a letter issued by the
suit for specific performance.
Lordship, suit for specific performance on the basis of a letter issued by the defendant's father. Lordship, wherein they have stated that, Your Lordship kindly takes up page 15.
Does not confer any title.
Lordship kindly takes up page 15 of my stay petition.
And if you treat this just an agreement,
Lordship.
the code of the stamp duty.
Lordship, that I'll pay the stamp duty, Your Lordship. Lordship, I'll pay the stamp duty at the time of when I'm tendering it at evidence stage.
Of course not. The code at the stage, that is a final judgment decision.
Lordship, when I'm tendering it in evidence.
You are not tendering. If you are going.
Lordship, then may I request Your Lordship to kindly remand it back because, Your Lordship, serving them will be a difficulty. Lordship, then may I request Your Lordship then to remand it back for adjudication, final adjudication of the interim.
Setting aside that order.
No. Lordship, I'm not asking for setting aside. I'm asking Your Lordships to remand it back to the lower court for. Yes, Your Lordship, the matter is pending. So because they have either left or refused.
Fine for surgery, my lord.
On the prayer of the an
For a short passover.
no Passover, madam. Who is the
Pradeep-
junior?
Pradeep Mukherjee.
Who is the junior? Where is Narayan Chandra Ghosh?
I don't know, Lordship. I have just instructed over the phone to.
Where is Narayan Chandra Ghosh?
Lordship, Mr. Narayan Chandra is stuck in traffic. He's not been able to come to the court premises.
We make it not today.
Lordship.
Next.
Serial number 20.
Lord, as per direction of this honorable court,
Yes.
for correction of the cause title,
To stay the execution. Why to stay the execution? What is this case? Second appeal. Second appeal. It's an affirmation or reversal?
Affirmation.
Affirmation or reversal?
Affirmation.
Suit for?
suit for declaration, one is suit for declaration and permanent injunction, and other was suit for declaration, recovery of possession upon eviction.
Recovery of possession.
But
yes,
there was a mistake in the cause title, and as per direction or last day's direction of this honorable court, we had
so one is with
title
regard
to 6 of 13.
So you filed a suit for declaration?
Yes, Mr.
An injunction, correct?
Yes, Mr.
Declaration as the occupier of my learned friend client
In
suit.
this suit,
Declaration of as the owner.
So it proceeds after a certain stage as ex parte.
My lord.
Because they did not proceed.
Sir, actually, my lord, his case was, my lord, that my lord, the shop room purchased from the joint family fund. But my lord, he has not produced a single paper, not my lord, adduced any evidence
that, my lord, it is for joint family, from joint family fund. And, my lord, on the other hand, my lord, the plaintiff in title suit number 20 of 2013, that is my client, the respondent herein.
You are the plaintiff.
My lord, in, my lord, title suit number 20 of 13.
Both the suits are heard together.
My lord.
Lord,
Because, my lord, the same issues are same. My written statement and their plaint.
Yes.
Lord, technical difficulty was that
No, we are not technical. You tell us substantive. What is the substantive ground?
So
What is
he
the
is, he is claiming you as a license.
My lord.
And what is your claim against them? Is a joint
My lord,
property.
he is, my lord, my brother, my lord.
So it is joint property.
No, my lord. There is
Yes,
his
my lord.
claim, but, my lord, the document exhibited by both the parties, my lord, not reflected a single.
What is your status so far as this property is concerned? So
My lord?
what is your status so far as this?
My lord, I am the owner. I purchased the owner from my own fund.
In 1995.
My lord.
He is also claiming to be a.
Lord, in
My lord,
1995
my
was
younger brother, my lord, on good faith, my lord, I allowed him with my family, and, my lord,
Yes, yes.
Lord, main contention was
subsequently he is showing Nelson eyes.
in the year 1995 he was 21 years old, just has passed become and purchased the property, all those property, and never resided there. Still, he is not residing there. All the property, there are so many properties. And one is purchased, suppose in my name, I'm one of the brother. The other is in his name. Where is not he? The property which is in my name, he is living there. Property which is in his name is in some other brother's position. That is another thing. The main difficulty in this suit is my suit was not heard finally. I was not permitted to adduce evidence. The date fixed for the judgment was passed before the date fixed for the final hearing, and everything is on record. Even in the first appellate court, matter has not been heard. Appeal has not been heard. Direction off the record, Milord, the appellate court said, you need not to advance any argument. I will see the records and will pass judgment. Nowhere in the judgment.
Cannot be acceptable now. It can.
যেটা এই অ্যাপ্লিকেশনটা আমাদের লোয়ার কোর্টে যেটা বার করতো পেজটাতে এটাতে
In this matter, my lord, most humbly, I am submitting before your lordship. I am the plaintiff and I am the appellant, my lord. It is a judgment of reversal, my lord, in the title suit, my lord. We have suit for eviction on the ground of reasonable requirement. Subsequently, it was hard. Subsequently, it was hard and it was allowed in our favor. And fact is that thereafter they preferred title appeal before the learned district judge.
Yes.
Observed to this extent a notice of eviction which we have served is not proper. The reason is that is 6 days delay in filing the notice of eviction. Actually, the contents of my application in the code below is that they are doing the business there and we are the mother and the daughter staying there in a most miserable condition which cannot be expressed. And furthermore, my lord, on this score, my lord, learned appellate court, my lord, was pleased to observe that since we have not served the notice in a proper form, that could not be accepted only on this ground. And next ground is that our contention is that they are not in the evidence. It is transparent, clear. They are not the original tenant, and they are forcefully occupying the suite premises. Though I was required to serve the actual file the application on the ground of trespasser, with but whatever may be the case, we have filed the application on the ground of reasonable requirement, and we have been living in a most heinous condition, and they're doing business merrily. On this particular page 15 of the judgment delivered by the learned Munsif in the court below, which will attract my rather support my contention to this extent. Lord, on this court, Lord, no caveat has been lodged, no copy of the application I was not required to file. And if your lordship so desires, my lord, I can actually file the copy of the applications, though no notice of caveat has been lodged. On this particular ground, my lord, I am most humbly submitting appeal should be heard, admitted. If your lordship so desires, there are defects in the.
To give 1 month's notice of eviction.
Yes, my lord.
You have to give
That
one
you have
month's
not given.
statutory notice.
That you have not given.
Statutory notice is that the original tenant is not conducting the shop. His brother
It has to be on a ground of trespass or other subletting.
No,
1 month's notice you have not given.
Learned Samota Das at judgment, page 15.
Page 15, if you will say, it will be transferred. It will be transparent, clear from the learned judge that
you have not. Have you given 1 month's notice?
Well, there is 6 days delay. 6 days delay. We have served.
What is this defect?
Yes.
My lord, it is the very clearly the Samota page 15. Oh, the conducting the shop is not the original defendant.
There's nothing to do with this a principle.
Yes.
Not the facts. If it is shortness of notice is there, then the suit you can file a fresh suit. There's no problem.
It will delay the proceedings. They will be occupying the.
Sorry, no.
It is that the fact that
Sorry.
My lord, taking up the record, my lord, on the last occasion, on last Monday, your lordship directed to remove the first defect, my lord. But a difficulty occurred, my lord, since last Wednesday, I could not come to court due to the medical difficulties of my father-in-law, man. I'm only praying for, my lord, a little accommodation, my lord.
All sad. All difficulties are in second appeal. Very well, you enjoy your holiday for the time being.
My lord,
After vacation.
grateful, my lord.
October. Second appeal admission আসছে।
The record, my lord.
October. Month, yes, you inspired this.
My lord, grateful.
October আসবে।
Great.
Bill number 23.
Your Lordship, I'm for appellant. It's a humble request. I'm
Second
praying for
appeal.
not today.
Second appeal.
I'm not aware of actually, Your Lordship.
Yes, can't hear you, madam. Please be little loud.
I'm praying for not today, Your
Why?
Lordship. The landlord, you were actually not able to come because his mother is sick, Your Lordship. It's a humble request, Your Lordship. Kind.
কত ও আইটেমটা চেঞ্জ করলেন হ্যাঁ এবার ফার্স্ট
অর্ডার আছে 2800 মার্চ
prayer for condonation of decay
অর্ডারটা দিয়েছে তো yes লিমিটেড আছে কোন অর্ডারটা চ্যালেঞ্জ because
19 to 25
19 to 25 yes the injunction application was
I'm praying for not today only, Your Lordship. Kind.
For this matter, I have sent the, I have already served the copy upon the the other side. I have the affidavit of side I have sent for affirmation. Within the short span of time, I will be receiving this affidavit of service. This is an appeal against an order of injunction. Defendant is the appellant before your lordship in a suit for declaration and injunction. Now, kindly have a look to the application for injunction. I have annexed the plaint. Kindly come to page 10 of the plaint, which I have annexed. Paragraph 3 onwards, of the plaint, it is said that the property fully described in para 2 above is owned by the present plaintiff and the defendant is the monthly tenant therein. So he has admitted me as a tenant in respect of the property let out to me, that the monthly tenancy is according to English calendar month on and from 25th May 2021 to 25th May 2024. Then paragraph 5, that the monthly rent for the suit premises is 2,500 exclusive of all other charges and taxes. Paragraph 7, the defendant is occupying the suit premises since 25th May 2021 to 24th May 2024 as tenant, and thereafter since 2024 the defendant is occupying the suit premises as forcible possession. Paragraph 9, that the brief facts of the plaintiff are on the facts of on the first month of May 2021, the defendant came to the plaintiff and requested to take on rent the property in question. that it is pertinent to mention that the plaintiff
Take down.
consider
Your Lordship's last order, the appellants were directed to serve copy upon all the respondents, my lords.
So what is, so we have not allowed your application as yet.
Yes, my lord.
We have not allowed your application as yet.
No, I'm for the respondent, my lord. Respondent.
Oh, you are now appearing.
I'm
You have
appearing.
been
I have
served.
appeared from the very beginning, my lord. I was on caveat, my lord.
So কোনটা allow করলাম আমরা দেখি sure. Legal heirs of Champa Mullik.
No, my lord. I am Tuktuki Dhara, my lord. The defendant number 1 in the suit in the court below. The plaintiffs.
This application was filed for addition of parties.
Yes. My lord, I have been appearing from the very beginning, my lord. I was on caveat.
না এই অ্যাপ্লিকেশনটাকে অ্যালাউ করলাম এটা কেউ লেখেনি
My lord.
That was which can is pending.
Can 2 for an injunction. The appellants has preferred an injunction application that is pending.
Appellant 2.
Can 1.
Can 1 টা দাও
Can 1. They had preferred that injunction.
ও can কি দাও opposing can 1.
I am opposing can 1. But this is from a refusal of an ad interim order of injunction, my lord. The plaintiffs have preferred this appeal.
Basing of title টা দেখাতে পারবো না when the matter is fixed.
The next date, my lord. The next date is fixed on 26th September, my lord. So if the injunction.
The appellant is
Service, my lord. I have served upon the respondents, my lord.
Have they received?
Respondent number 1 has received, its executive officer has received. Respondent number 2 has not received, but the one of the directors who was representing the respondent number 2 has been received. I have served individually, lordship. My lord, this appeal has been preferred, my lord, by the plaintiffs, challenging the refusal of ad interim order of injunction, my lord.
No, but you see that the reason has been given.
Lordship.
The reason what is given for
Lordship.
ad interim prayer, what is the wrong with that?
Yes,
and when the matter is fixed.
Lordship, may kindly take
when
the
the matter
lordship
is
impugned order, lordship.
When the matter is fixed.
Matter is fixed on 8th April 2026.
Lordship, kindly see the impugned order once, Lordship, page 66 of my CAN
Yes,
application.
please.
May I read out? On the perusal, prior to last paragraph, having heard the submissions of learned advocate for the plaintiffs, and on perusal of the materials on record and the documents filed by the plaintiffs, it appears the court, it is positive case of the plaintiffs that their predecessor in interest, namely Kalipada Ghosh, was the absolute former owner of the suit property, from whom the plaintiffs have acquired the suit property. Whereas having produced the RSROR of the suit property, as filed by the plaintiffs, it appears to this court that the suit property formerly belonged to Kalipada Ghosh and Panchanan Ghosh to the extent of half share of each. This is the reason, Lordship, my injunction prayer was refused. Now, Lordship, kindly peruse the RSROR. My suit property is 31 decimal and RSROR reflecting 65 decimal in those two that. So my 31 decimal is still lying. Consider my LR Lordship. My property, 31 decimal property, is consisting in 3 LR DAG numbers. From page 61, your Lordship will find my LR RORs on behalf of the 4 plaintiffs. Page 61, Lordship.
What prayer you have asked for?
I have asked for, this is a suit for recovery of possession, declaration, permanent injunction.
You became a co-sharer, so you...
No. I have no tussle with my Lord Panchanang Ghosh and others. What the company has done...
What is your prayer in the injunction application?
My prayer is that the company may not create any further, change the nature and character of the suit property any further, and do not create any third-party interest over there.
No, who is this Kalipada Ghosh?
Kalipada Ghosh is my predecessor, Lordship, and Panchanan Ghosh was the brother of Kalipada Ghosh. Now, RSROR consisting 65 decimal of land.
Who is the original owner of that property?
My Lord, I have found RSROR, and from that it belongs.
Now, who are these Shuman and SFA? Who are they?
They have not purchased the property. And my kindly, Lordship, consider my LRROR.
Where is the plaint? Show us a plaint.
Yes, Lordship. My plaint is starting from, Lordship, page number 13, Lordship. Lordship, this company is acquiring property since very long. And they have not purchased my property. And these 3 LR DAG numbers is totally belongs to me.
They are putting walls over the adjacent.
No, they are putting walls. They are
adjacent to you.
No. Firstly, they were putting walls adjacent to my property. Thereafter, they totally acquired the property and surrounding many others property. It's a huge, they are acquiring a huge quantum of property. And just because I have not agreed with their price, they offered me. I have not agreed with that.
You have to show you are the owner.
Yes,
and there's an encroachment.
Yes, Lordship.
So they have already encroached.
Yes, Lordship.
So where is the encroachment? Have you filed any application for appointment of a commissioner?
Lordship, I have just preferred the application, moved the ad interim application. I
has to pass an order which is meaningful.
Yes, Lordship.
So they have first they raised a boundary wall.
Yes.
Then they did not file any suit.
Yes,
then
Lordship. Lordship, kindly consider, Lordship, they have acquired my property. Property belongs to me, Lordship. If your Lordship kindly consider the records and the instruments have been created in my favor. Now,
have you served them? Where is the affidavit service? Have you served?
Yes, Lordship.
Affidavit service.
Affidavit service I have filed, Lordship. Kindly, Lordship, I will definitely file order 26 application, Lordship, before the learned trial court. But prior to that, kindly protect me by passing an interim order, Lordship. That is my humble prayer, Lordship.
6/9/2020.
One has received, its executive officer has received.
Executive officer of?
Respondent number 1. 2, the consignment returned on behalf of the 2, but its director, one of its director who is representing respondent number 2, he has received the consignment.
Other defendants or respondents?
No, Lordship. No, Lordship. Kindly see my cause title of my plaint, Lordship. Only 2. 2 of them, Lordship.
But in the only 2 defendants, no?
Yes, Lordship.
Both of them have been served.
Both the director of respondent number 2, consignment of the respondent number 2 has written, but its director has received the same. And the director of the respondent number 2 is the executive officer of the respondent number 1. They have every knowledge. Lordship, they have no papers to show that they have acquired the property lawfully.
Kalipodo was the absolute owner of the property.
Kalipodo and Ponchanan Ghosh.
So Ponchanan share, Ponchanan may have sold. They may have sold it to this company.
Yes, Lordship. Lordship,
So
Lordship, kindly allow me, Lordship. The 3 LR ROR, 3 LR.
Forget about LR ROR. If Ponchanan's heirs have sold the property,
yes, Lordship,
then Ponchanam
they may claim, but the 3 LR dag numbers, Tholoana totally belongs to me.
LR dag number, whatever.
3 LR dag numbers belongs to me, Lordship.
If there are co-sharer, then how can it exclusively belong to you? If you file a suit for partition.
Lordship, the land 31 decimal land presently, Lordship, consisting in 3.
Forget about presently. Kalipodo and Ponchanam, they were joint owners.
Joint.
So you cannot say I'm in exclusive possession of 31 recorded in my favor.
RS, that was in
So
RS.
how the court says that we want to know the full facts.
Now LR Mauja map has been prepared. My portion has been demarcated.
How can you have a demarcated portion when a partition is not being there?
Lordship,
partition is not. Have you filed a suit for partition?
No, Lordship, I have not filed a suit for partition.
Heirs of Ponchanan may have sold. You don't know.
Kindly allow me to submit, Lordship. Kindly allow me to. Presently, after RS, LR map has been prepared by the Mauja LR map, and in 3 dag numbers, I am Sholoana.
I want to know from your title.
Yes, Lordship.
Yes, LR do not create any title.
My position, Lordship.
Poison. Then
Lordship,
you have to show the title first.
If this Ponchanan has already sold, then they become the co-sharer.
They may become, but they have no right on these 3 LR dag numbers.
How could you? If this
because it totally belongs to me.
If this property is a joint family property, Kalipodo half share he has sold.
Half
share has sold to you. Gifted to you. The half shares are others.
My predecessor, I have got it on
So Ponchanan has half share.
When the next date is fixed for
8th April, Lordship. Kindly hear me once, Lordship.
So you file
there were 2 RS dag number, 22 and 35. Lordship,
May I please, Your Lordship?
Yes.
Lordship, kindly remember last occasion, the matter was appeared before Your Lordship. This is two matters. I am representing the tenant, my lord. The suit was filed by the my learned friend's client to evict me as a trespasser. The first suit, my lord, that eviction of trespasser has been decreed. Challenging that decree, my lord, I have preferred the first appeal. And the second appeal is, my lord, with regard to my suit for declaration of my tenancy right. Now, the first suit is concerned, Your Lordship, kindly remember last occasion when Your Lordship was concentrated only on the point of the rent receipt, as it has been Exhibit 1, and the letter has been issued by one of the co-sharer of the suit property, Sitaram, in favor of.
You are the purchaser. You are the purchaser.
He is the purchaser subsequent. He is a subsequent purchaser. Letter of adjournment was there, and we have accepted him as a landlord. Now, the nature of suit, my contention was the very short point to be determined by Your Lordship, whether I am a tenant or a trespasser. If I am tenant, I will be guided by 97 Act, and if I am trespasser, I will not. Now, Your Lordship kindly sees, last occasion, two documents was presented before Your Lordship. I asked my client thereafter, instructed him to whether any document to show that Dilip Nath's existence is there. Because Dilip Nath is, my lord, inducted me as a co-sharer of the property. My lord, I have found some documents, which, my lord, I would like to, my lord, produce before Your Lordship. And of course, my lord, I will file, my lord, application under Order 41, Rule 27, because I have such right, my lord. Your Lordship kindly sees, my lord, these are the documents, my lord, I have found, my lord, subsequently. Some of the, my lord, electricity bill, which has been exhibited, and, my lord.
No, but have you, the suit that was filed, the other co-owners were not made parties.
No. They both purchased.
The owners of the property.
They has now become the owner.
Dilip, the suit that was decreed, just prior to your purchase.
No. After I purchased the suit, I filed the suit. I filed the suit.
By that time, Dilip expired.
He first says Dilip Nath was my landlord. Now he tries to make a case that Dilip Nath Boral and Dilip Kumar Nath is the same person. In both the suits, that has been rejected. Before the rent controller, that has been rejected.
But no suit for eviction was filed by the Dilip or the co-sharers.
No.
It is only after you purchase, you filed it. So that Dilip's letter is of 1998, something like that.
Much before.
Your Lordship kindly sees.
He tried to establish this, and also one thing that is why Your Lordship called for.
I am still on the point that Dilip Nath and Dilip Kumar Boral are the same and identical person. I can show several documents. I will show several documents that.
When?
I'm telling Your Lordship, Gosto Bihari Nath and Geeta Rani was the original owner of the suit property. That is 5 Sikdarpara Lane. They are that is not disputed. That is proof.
We direct FAT 298 of 2024. ওটা কোথায়? লিস্টে আছে তো নিশ্চয়ই। অ্যাপ্লিকেশন দাও কি আছে?
See his written statement. He does not know who his landlord is. He comes to know from a third person whose landlord
Suit
is.
number 238 of 2014 was filed by whom?
By my client. This is the plaint. Your Lordship kindly.
No, fine. We have.
Oh, সেই যে পেন্ডিং আছে হয়নি এটা বলছি।
So you filed a suit against whom?
I filed the suit, my lord, against
Topesh Singh.
Topesh and Anita
Against
Singh.
me, against me.
Against them, because
2014.
yes,
Which was also dismissed.
and that is why appeal has been preferred. Your Lordship kindly sees paragraph 6 of the plaint. If Your Lordship have the page.
Very strange.
দাদা তুমি বলবে আগে না আমি বলবো? তুমি যদি মাঝখানে বলো তাহলে প্লিজ।
And using the same, let's go down for the purpose of his business. He has a statute measure that they official control as a tenant. Measure under the supervision of the
সেকেন্ড ম্যাটারটা মেনুটা বলো। My declaration suit has been dismissed simply, Lordship. Yeah, I'm sorry.
state adoption by prior to that he granted this to the state. Definition for the is the not for the plaintiff. In the owners by virtue of the parties. They appear the plaintiff is in contract. The state to conduct and what to do the owners from society. It is the dependent with the probably the purchase and the address of purchases are not mentioned.
Seven default.
Seven documents. Copies of two televisions telling dates of the word there's one presidency after that. একটা ডকুমেন্টও দেখিয়েছি, দেখিয়েছি। একটা ডকুমেন্ট তার মধ্যে two time receipts carrying 89 and 97. So Shitanath died when?
Sitanath Milord died before Milord, his heirs sold the property by the deed, Exhibit 6.
No, sale takes place when?
Sale date is
Sale deed 2011, Milord.
2011.
So Shitanath died
29th day of July 2011.
Yes.
Is a deed.
Deed of conveyance.
29th of July.
So that agreement does not mention in name or it has given a list of tenants or occupiers. Sometimes an agreement gives the
Schedule,
list.
can you see the schedule? That is
schedule.
why your lordship asked for the conveyance, because your lordship wanted to
Where is the
see the
conveyance?
schedule. And in the schedule is
Page?
occupied with some strangers and or trespassers, no tenants.
Some, not all.
No, but doesn't mention about any tenant as such.
No, nothing. Kindly see.
That is their heirs, not by Sitanath.
Today he is claiming to be a tenant. He has to prove he is a tenant.
Yes.
Neither he has made an application under 7172. Neither he has deposited the rent.
No, so this person, this is by Shitanath.
This is by the heirs of Sitanath.
That is by the owners of the property who has conveyed it to me.
Who are the owners?
They are heirs of Shitanath.
Chandras.
Yes.
Chandras.
Who are
They are shares of Shitanath.
Yes.
So when you purchase a property, did you make an inspection of the property?
Obviously, they when one buys the property.
Now, did you make an inspection of the property? Joint inspection, requisition on title. Did you find out what is the present status? Who are in occupation? Because you have purchased a property, I take it that you purchase it with some encumbrance. So that is factored against the consideration price determined. So at the time when you purchase the property and you knew that it is encumbered, so have you asked for them that whether, like a requisition title, have you asked from them whether this property is encumbered?
It occupied portions of strangers and not trespass in the ground and first.
Only when you purchase a property.
Yes, that is otherwise you are deemed to have constructive knowledge of the.
So once they say you ask for that, is there any tenant or is there any
No tenant. We have been instructed all trespassers.
instruction? When you purchase, buyers be aware.
Yes.
So you are the buyer. So when you purchase this property, did you ask from the tenant, the owners, please give us a list of the occupiers? Because this is very vague.
I
It's
can't
very
say.
vague.
I
Hear out the appeal, we'll hear out the appeal. Take down.
But then only one thing, your lordship.
Lordship, 29 on last occasion, I took time for the petitioner was ill, Lordship. Still, he is sick, Lordship, and sent the brief to me, Lordship. If your Lordship kindly allow me or other. Or Lordship, your Lordship kindly take the matter, direct the matter to appear after.
I am for the respondent. On previous occasion, my lord.
The Lord already decided the issues, my lord. I have nothing to say in this matter. The Lord already.
I am covered by the my lords.
Earlier judgment, my lord, regarding section 5.
In this case, delay is 3,900 days. My lord, may I corrected one? Can you see?
Yes, the name will change.
My lord, delay some date, my lord.
It is a corrected one.
Yes, my lord.
Next. Matter. But if today is not taken up, tomorrow I shall personal deputy. My lord, Lordship kindly, there are other matters, my lord. Tomorrow I will not come, my lord. That's why, my lord. 51 to 60. 61 to 73.
30. Delay to change.
If not taken up to today, my lord.
Delay to change.
61 to 73.
1 to 73.
31.
Tomorrow I have some personal, I will not come.
31 delay 3,650 days.
1 to 70.
In 6-5.
51 to 6 and 61 to 70.
51 to 60.
60.
0 and
61 to 73.
So
these are all analogous matter.
all 73.
Yes.
So 51 to 73.
Yes. But tomorrow, my lord, I have some problem personal, I will not come.
My lord.
Today we'll sit up and we can touch some matter, otherwise we'll keep up there. No, please other side.
No, my lord, there is no, there are delay, my lord, I have to serve.
They have not served. None of the applications.
No, there is no caveat, my lord.
You have to serve and
I have to serve.
Then I have to order for it. So give the name of the appealing counsel.
Serial number 32.
Yes. Daku. 32. Risho, you asked. Yes, yes, yes.
My lord, 32 evict to appear for the petitioner, my lord. Lord, I'm led by Mr. Shobushaji Chatterjee. In the meantime, I will start and you will join his
No,
on
but,
another court. My lord,
and
my,
you have to serve.
my affidavit of service. Yes, my lord, a caveat has been filed by them, my lord. I have served to the advocate.
No, where is the appeal service?
Yes, my lord. Yeah. Sorry. Can yet the petition
Appropriate order. So match.
And delivery to check. Huh?
Vishnu Mariga. Is it a contested or?
Yes, my lord. This is on contest, my lord. Lord, may I please the facts in short, my lord?
So just a minute. There's a delay of 273 days. So if he has married in the meantime,
My lord,
can't
if
help
he is married, then the case is in my favor because I want a relief from my husband, my lord. He's not.
he's married in the, so if we are not appearing with personal service, take down. In spite of service. Yes.
My lord, what intelligence, my lord, has. My lord, 28 is the first working day, my lord. No,
Second working.
Second. Right. Right.
May I please, Lordship? My lord, this is plaintiff appellant's application arising out of a suit for specific performance of contract.
You are appearing.
In my lord, on behalf of opposite party, Mr. Tapojit Dey, he is seriously ill over telephone. I am praying for my lord after vacation, my lord.
No, sorry, can't follow.
Tapojit Dey for the opposite party respondents, my lord.
He has not come.
No, my lord, he is seriously ill over telephone. He told me, and after vacation, my lord.
My lord, may I make my submission to some extent, my lord, because the interim order is necessary. I got the interim order till the disposal of the suit in the trial court. They didn't appear. Even, my lord, on the date of hearing of the application for injunction, my lord, they appeared and prayed for extension of time for filing written statement, but they didn't file any objection against the injunction application. And the injunction has been made absolute.
It is against the decree.
My lord, yes, against the decree for this degree of dismissal, my lord. Suit for specific performance was dismissed.
Yes.
So, my lord, till the disposal of the suit, my lord, injunction was extended. They didn't appear there.
Will not affirm the claim of the plaintiff, neither it will get it right. No, you are found to be in possession. That's all.
My lord.
You are found to be in possession.
There are 3 agreements, my lord, for.
No, why it was dismissed?
My lord, first objection was it is a key non.
Unregistered
Unregistered power. At that time, my lord, when the power of attorney was executed, my lord, there was no such.
Unregistered power of attorney point is valid.
After that execution of that, it was made compulsory registrable after the.
No.
Present time.
When the power of attorney holder signed the agreement, so he did not have the power of attorney. So he did not have.
No. At that time, he had the power of attorney. On the basis of his power, my lord, he executed 3 agreements.
But that is unregistered.
My lord. Unregistered, my lord, at that time, my lord, it was not, registration was not made compulsory. It was made compulsory afterwards.
Later.
Yes.
Which year? Power of attorney?
Just a minute, my lord. Give me.
Was it fully so?
My lord?
Entire stamp duty paid?
Yes.
At the time of agreement? Yes, sure.
So, my lord, এটা কার?
এটা আমাদের